Republic vs. Court of Appeals and Hughes, Gr. Number 100835, October 26, 1993. Facts: James Anthony Hughes, a natural-born citizen of the United States of America, married Lenita Mabunay Hughes, a Filipino citizen, who herself was later naturalized as a citizen of that country. On June 29, 1990, the spouses jointly filed a petition with the Regional Trial Court of Angeles City, Branch 60, to adopt Ma, Cecilia, Neil and Maria, all surnamed Mabunay, minor niece and nephews of Lenita, who had been living with the couple even prior to the filing of the petition. The minors, as well as their parents, gave consent to the adoption. Regional Trial Court rendered a decision granting the petition. Court of Appeals affirmed the decision of the RTC. Issue: whether the petition for adoption of spouses Hughes should be granted. Held: no, it is clear that James Anthony Hughes is not qualified to adopt. Article 184 of the Family Code provides the following persons may not adopt: 3. An alien, except a former Filipino citizen who seeks to adopt a relative by consanguinity, b. one who seeks to adopt the legitimate child of his or her Filipino spouse, or c. one who is married to a Filipino citizen and seeks to adopt jointly with his or her Filipino spouse a relative by consanguinity of the latter. Aliens not included in the foregoing exceptions may adopt Filipino children in accordance with the rules in inter-country adoption as may be provided by law. While James Anthony unquestionably is not permitted to adopt under any of the exceptional cases enumerated in paragraph 3 of the aforequoted article, Lenita, however, can qualify pursuant to paragraph 3a. The problem in her case lies, instead, with Article 185 of the Family Code expressing as follows: Article 185. Husband and wife must jointly adopt, except in the following cases: 1. When one spouse seeks to adopt his own illegitimate child, or 2. When one spouse seeks to adopt the legitimate child of the other. Lenita may not thus adopt alone, since Article 185 requires a joint adoption by the husband and the wife, a condition that must be read along together with Article 184. Article 185, Family Code, thereof now expresses the necessity for joint adoption by the spouses except in only two instances: 1. When one spouse seeks to adopt his own legitimate child, or 2. When one spouse seeks to adopt the legitimate child of the other. It is in the foregoing cases when Article 186 of the Code, on the subject of parental authority, can aptly find governance. Article 186. In case husband and wife jointly adopt or one spouse adopts the legitimate child of the other, joint parental authority shall be exercised by the spouses in accordance with this code. The respondent court, in affirming the grant of adoption by the lower court, has theorized that James Anthony should merely be considered a nominal or formal party in the proceedings. This view of the appellate court cannot be sustained. Adoption creates a status that is closely assimilated to legitimate paternity and filiation, with corresponding rights and duties that necessarily flow from adoption, such as, but not necessarily confined to, the exercise of parental authority, use of surname of the adopter by the adopted, as well as support and successional rights. These are matters that obviously cannot be considered inconsequential to the parties. Wherefore, the petition is granted and the decision of the respondent court is reversed and set aside. No costs.